Good morning, Mr. Dukwana. Good morning, everybody.
Good morning, Chair.
Yes, are you ready?
Chair, we are ready to proceed. Chair, you will recall that earlier this year, Mr. Dukwana appeared before this commission. He adduced evidence, supplied this commission with documents, and he also promised, Mr. Chair, that he will be returning to this commission to submit further statement and to adduce further evidence before this commission. Mr. Dukwana, as promised, Mr. Chair, he has now returned before this commission. However, Chair, before leading his evidence, permit us to deal with a number of preliminary issues in order to place these proceedings in their proper context. Firstly, let's do that by dealing with the documents which must be before you. We have placed a file before you, Chair. You would recall that during the first appearance of Mr. Dukwana, a reference was made to Exhibit X. So we have prepared a file. You'll see, Mr. Chair, that the first folder contains Exhibit X, which is Mr. Dukwana's previous statement. And during the very same proceedings, Mr. Chair, if you may turn to folder number 2, you will then find the supplementary affidavit, which was also handed in by Mr. Dukwana during his previous appearance before this commission, and it was through the leave of the Chair that it was marked Exhibit X1. And Mr. Chair, there were also 2 further documents which were relied upon and referred during those proceedings, and you'll find them at folder number 3, which is Exhibit X2, and the other document that follows immediately thereafter, it is Exhibit X3 at folder number 4, Mr. Chair. Those are the documents which served before this commission previously. We thought that for completeness and to the extent that it may be necessary, we should include them in this bundle so that if there is a need to refer to same, at least we do have those documents handy before this commission. Now, Mr. Chair, you'll also recall that we did make mention, even though we did not submit that document formally before you, we did make mention of an affidavit which was deposed to by Mr. Iqbal Sharma. But it was not in terms of any rules of this commission. It was not a 3.4 application, and therefore we did not place it formally before you. However, Mr. Dukwana, in his current statement, deemed it necessary and prudent to deal with the averments that appears in that affidavit. And for good order, Mr. Chair, we thought that we should put it before you, and you'll see that if you turn to folder number 5, and with your leave, Mr. Chair, we propose that it should be referred to as Exhibit X4.
It shall be so marked and so referred to.
Yes. And Mr. Chair, the last document which is relevant for today's proceedings, you'll find it in folder number 6. It is a further statement which was handed to the commission by Mr. Dukwana in order to deal with the further evidence and the further aspects arising from the different topics which he canvasses in the statement. And with your leave, Mr. Chair, we therefore propose that it should be marked as Exhibit X5.
It shall be marked Exhibit X5 and shall be referred to as such.
Yes. Mr. Chair, I'm told that there is a 5-page supplementary which is still being paginated properly by some of the members of the legal team. When we have it at our disposal and at an appropriate time, we'll then make it available to the chair. That is a supplementary, simply annexing one or two annexes and correcting some of the things in the initial affidavit. But for now, we're simply making the chair aware of saying we are not going to deal with it for now, Mr. Chair. Now, evident, Mr. Chair, that after having received the further supplementary statement, the further statement of Mr. Dukwana, in order to comply with the Commission's rules, the 3.3 notices were dispatched to various parties. I must mention, Mr. Chair, that in this statement, not less than 30 3.3 notices were dispatched. And for completeness, Mr. Chair, we prepared a schedule that will, in due course, hand to the chair, indicating that on the 1st of August, which is 26 days before this hearing, the Rule 3.3 notices were dispatched successfully to the following people: Mr. Elias Ace Mahashuli, Ms. Sarah Matawane Mlamleli, Rev. Daniel Mutobilekota, Mr. Thabo Ntumetsi Mukesi, and Ms. Kabate. And then the other 3.3 notices, Mr. Chairman, were dispatched on the 31st of July, the one of Ms. Lydia Mutsime, which it was dispatched 27 days before this hearing. And we have the other ones that follows were dispatched on the 1st of August, giving the respective parties more than or approximately 26 days before this hearing. And those were Morake Ipileng Octavia, Cholate, Ms. Cholate, Ms. Refilo Mokwena, Mr. Blakey Siwe, Mr. Kupeng Rale Konzani, Mr. Iqbal Shama, Mr. Edwin Sodi, Mr. Musebenzi Zwani, Mr. Shadrach Ramate, Mr. Miss Hansi Betilda Matsike Mayeza, and Mr. Titus Mudau Nechi Vo Zame. Mr. Chair, all those had the notices 26 days before this hearing, and the remaining ones were dispatched on the 5th of August. That is the one of Ms. Shelima Zibuko. And on the 21st of August, it was the one of, on the 5th of August, Mr. Chair, is the one of Shilama Zibuko, Rev Mutobi, Ms. Nangu, Ms. Togo Alice Malembe, and Mr. Situmo Solomon Ntsele, and the ones that were dispatched on the 12th of August, still providing 14 days to the parties, was the one of Mr. Silo Joseph Khadebe, Ms. Melanie Liz Mitchell. So all of the parties, Mr. Chair, on our count, it is almost 30 of the parties which were served with the notices. What has transpired, Mr. Chair, in order to avoid any unfair criticisms, there's always been a debate whether a party is being implicated or whether his name is merely mentioned. In order to avoid that and to err on the side of caution, every individual or person mentioned in the statement of Mr. Dukwana was therefore favored with a Rule 3.3 notice for that party to make an informed decision whether or not to invoke any of the rules of the Commission, so that we are not being criticized that names of parties are mentioned for the first time during the oral evidence and parties claiming that they've not received the 3.3 notices. Because sometimes we take that stand to say that by mere reading that statement, the parties were implicated. But somebody might say that, well, I was supposed to have been favored with the 3.3 and to exercise that right. But for these proceedings, we have made sure that everybody mentioned must be favored with that copy, Mr. Chair. To the best of our knowledge, and as far as we can ascertain, Mr. Chair, we have not received a 3.4 application in a strict sense of what is required in the rule of the Commission. However, Mr. Chair, there's been serious reaction by different parties. Others might have chose to respond by mere letters. Others simply put an affidavit and say that it's an affidavit in response of the allegations. And we thought, Mr. Chair, that for completeness, we should nonetheless place that correspondence before the Chair so that we are not criticized for having left out any of what might be material evidence or criticized for suppressing any of the documents which came at our disposal. Allow us, Mr. Chair, to do so with reference to a file that we have prepared, and we have called it a correspondence, a Rule 3.3 correspondence bundle. And I think that is quite important that we should at least place some of the activities pursuant to the statement of Mr. Dukwana and the 3.3 notices have been dispatched. We have separated that, Mr. Chair, with different folders. We will only refer you in order for the Chair to get the gist to the relevant pages and to the reaction to the letters received and the reaction thereto to those letters. The first folder, Mr. Chair, pertains to Mr. Ace Makashule, but it only relates to his initial statement. If we may refer the Chair to page 16, it will give the Chair a better understanding as to where we are heading with this correspondence. At page 16.
I've got page 16, but before you get into what the correspondence says, shouldn't we have all legal representatives who are representing various?
Yes. We can do it now, Chair, but I thought that maybe I would afford them an opportunity after I've placed this, but we can do that now.
Yes, let's.
Chair, there are a number of parties
yes,
that have been represented,
yes,
including Mr. Dukwana.
Yes.
They can place themselves on record. They can also decide
yes,
as to how they wish to react.
Yes, at this stage, let's just have them place themselves on record, and then we'll take it from there. Then we'll revert to Mr. Mkwena.
Yes.
Good morning, TCJ.
Good morning.
Smanga Sitini. I'm instructed by Mr. Mashala, Stanley Mashala, who's here. I am job shadowed by Ms. Jamila Maepa, who's a law student. I am for the witness, Mr. Mxolisi Dukwana.
Thank you very much.
Mr. Chairman, duly instructed by Maharaj Attorneys of Durban and appearing with me, Mr. Shane Dial, SC of Durban, I appear on behalf of a witness whose name I will not disclose, but whose name has been disclosed in chambers.
Yes.
The reason for my not disclosing his name will be evident when I'm given an opportunity to address the Commission.
Thank you, Mr. Helens.
Esteemed Chair, Libala
Yes.
is my name. I appear for the Director General in the Premier's office, Mr. Kopung Ralikonzani, with my colleagues, Ms. Maiti and Mr. Manye, instructed by the State Attorney, Mangaung,
Yes.
permit me to mention to you that we lament one aspect that we've had, that there's no party that has provided a Rule 33.4 statement in the literal sense. We want the record to reflect that we did, in line with the rules of the Commission.
Yes. Okay, thank you.
Chair, my name is Jerome Levitz. I'm from the firm Flaxmans, and I represent Edwin Sodi.
Thank you very much. Thank you.
Morning, Mr. Chair.
Morning.
I'm Pranav Jagan from Pranav Jagan Attorneys. I've been instructed by Mr. Titus Madawa Glenn Nechivodzwa.
Thank you.
Thank you, Mr. Chair.
Okay.
Morning, Chair.
Good morning.
I am Tlilai on behalf of Ms. Mnamleli. Thank you, Chair, from Moroka Attorneys.
On behalf of?
Ms. Mnamleli, Oli Mnamleli.
Thank you.
Thank you, Chair.
Okay.
Good morning, Chair.
Good morning.
I'm Manye from Bloemfontein. I'm here representing Mr. Sewe, instructed by Mxolisi Attorneys.
Thank you.
Thank you, Chair.
Thank you.
Morning, Chair.
Good morning.
I'm Mr. Njokweni, instructed by Setu Monsele. Thank you.
Thank you. Yes, Mr. Mkwena. You had asked me to go to page 1616.
Yes, Chair. I must comment that parties are well represented, Mr. Chair.
Yes.
Mr. Chair, if we can take it from page 116, you'll see that from the date, it's dated the 11th of April 2019. It was, and if you turn to page 17, this is the letter which is signed by Mr. Elias Makashule. And in his letter, if you may place it on record, Mr. Chair, you see that I refer to the above matter as well as my letter transmitted to you via email on the 2nd April 2019. I have noted that during Dukwana's evidence...
Hang on one, Mr. Mkwena. Is everybody able to hear? At the back, is everybody able to hear? Well, nobody says no, so it must mean they are all able to hear you.
Yes, Chair.
Okay, thank you.
Nonetheless, I'll try to raise the voice for the Chair's sake.
Yes.
I have noted that during Dukwana's evidence, that reference was made to a supplementary affidavit, and he apparently submitted to the Commission on the 5th April 2019. Contrary to previous two occasions, I was neither notified nor provided with a copy of that affidavit. I would appreciate it if I could please be furnished with that supplementary affidavit, which appears to have been marked Annexure X1 during Dukwana's testimony in the Commission. This would assist me when I made my election as sought in the notice in terms of Rule 3.3 that was served on me. I have also noted that Dukwana seems not to be done with his evidence. If I am correct, kindly advise me as to when the Commission's legal team is expected to finalize his testimony. I am of the considered view that I am unable to make an informed election until Dukwana has finalized his testimony and I have been placed in possession of his supplementary affidavit. In the interim, I elect to reserve my right. Now, Mr. Chair, if the Chair may turn to page 3, you will find comfort in knowing, Mr. Chair, that Mr. Makashule was therefore placed in possession of Annexure X1. but there was a letter also reacting to it from the Commission dated the 10th of May 2019, where it reads as follows: we refer to your letter of 11th April 2019 and the evidence adduced by Mr. Mxolisi Dukwana before the Commission. As you are aware, Rule 3.3 of the Rules of the Commission provides that. Then it's set out in details from the Chair. I would not read it in order to save time. And if you turn to page 4, you are furnished with a Rule 3.3 notice and the statement of Mr. Dukwana to the extent that it implicated you. As you are aware, there are time periods prescribed within the rules of the Commission. Then reference is made to Rule 3.4, Mr. Chair. Then paragraph 5 proceeds to state as follows: to date, we have not as yet received any application from you as contemplated in Rule 3.4 pertaining to the Rule 3.3 notice which was dispatched to you, containing the portions of the evidence of Mr. Dukwana to the extent that his witness statement implicated you. 6, Mr. Chair, please find the supplementary affidavit with annexures to Mr. Dukwana on the Commission's website. Indeed, Mr. Dukwana has not finalized adducing evidence before the Commission, and we are still awaiting his further statement. At this stage, as the Commission, we are not in a position to indicate whether or not his further statement and or testimony will or may implicate you. We can only make that call once we are in possession of his further witness statement. And 8 indicates the address, Mr. Chair. As I've indicated that a Rule 3.3 was also sent pertaining to this new statement of Mr. Dukwana, affording Mr. Makashule 26 days upon which to react. There's never been any correspondence in that regard.
Yes.
Mr. Chair, if we can move to folder number 2. Folder number 2, it is correspondence from a law firm, Shahid Dolly Incorporation. You'll see that the first letter is dated the 3rd of April, 2019, and they are representing Mr. Iqbal Sharma. What they've done, Mr. Chair, they have submitted this correspondence and subsequently they then simply forwarded an affidavit, the one which I've referred to as Exhibit X4. And
Yes.
thereafter,
Is that Mr. Sharma's affidavit?
yes, Mr. Sharma's affidavit.
Yes.
So what was then done, Mr. Chair, if you can turn to page 26. Then the Commission also dispatched a letter to Mr. Sharma's legal team, whereby it highlighted quite a number of issues. At paragraph 1, it said, we refer to the evidence of Mr. Dukwana, which was adduced before the Commission, including the Rule 3.3 notices, which was accordingly dispatched to you. As you are aware, 2 days prior to Mr. Dukwana's adducing his evidence before the Commission, you dispatched a document and or affidavit styled statement in response to the allegations in the statement of Mxolisi Dukwana, close inverted commas. Your affidavit was not an application as envisaged in Rule 3.4 of the Rules of the Commission, and it was not apparent as to how it should be dealt with, as it did not comply nor conform with any of the rules of the Commission. Then Rule 3.3 is rehashed there, Mr. Chair. And if you turn to page 27, at paragraph 5, it says that it is apparent from the affidavit that you had filed that it does not comply nor conform with Rule 3.3, and it does not state whether or not you wish to exercise any of the rights provided for in the aforesaid rule, as provided for in Rules 3.3.61 to 3.3.63, which of course include you testifying before the Commission and to be cross-examined. And Rule 3.4, Mr. Chair, it's indicated on paragraph 6. And if you turn to page 28 with me, Mr. Chair, we say that your affidavit does not appear to be an application as envisaged in Rule 3.4. Could you please clarify why you had filed your affidavit and how it should be dealt with in the light of the rules of the Commission? This affidavit was not formally placed before the chairperson, as it was not put to Mr. Dukwana in order to react to same, as it did not conform nor comply with any rules of the Commission, and as such, it was kept in abeyance in order for you to decide whether or not you wish to invoke any of the rules of the Commission. For it to be properly admitted in terms of the rules of the Commission, we await your response in this regard. From that date, Mr. Chair, up until now, there was no further correspondence from Mr. Iqbal Sharma pertaining to the evidence of Mr. Dukwana, as well as the 3.3 notices and the correspondence that was dispatched to him subsequently. If we can then move, Mr. Chair, to folder number 3. Importantly, it's page 33, which is correspondence from MS Ramate CA, in brackets SA. Also, they say that if you read paragraph number 1, it says, I hereby acknowledge receipt of the Commission's correspondence dated the 2nd August 2019 regarding Mr. Mxolisi Dukwana's affidavit and intended appearance at the Commission. On the 3rd of August, I requested additional information to allow me to make an informed decision on how to react to Mr. Mxolisi Dukwana's claim as per paragraphs 107 and 108 of his affidavit. Because of the limited information at my disposal, I am unable to decide on the best course of action. I, however, deny that I was involved any wrongdoing as alleged or inferred by Mr. Mxolisi Dukwana. I further specifically deny the following: that I have ever been appointed as an individual by Mr. Magashule to sanitize any report, that I have any personal knowledge to any entity called Ramate/Fivers being appointed by Mr. Magashule to sanitize any report, that I have ever sanitized any report or been party to sanitizing any report, that I have any knowledge of Mr. Fivers sanitizing or being party to the sanitizing any of the report, that I have even had sight of any sanitized report or reports which Mr. Mxolisi Dukwana may be referring to, that I have ever had any fallout with Mr. Fivers, that I have any knowledge of Mr. Fivers ever forming an entity called Open Waters. The last paragraph says that, for the record, I was at one stage a non-executive director of an entity called Ramate Fivers Forensic Investigation Accounting Services Pty Ltd, to which Mr. Mxolisi Dukwana may be referring to in paragraphs 107 and 108 of his affidavit, Mr. Chair. So this is the reaction, but he was only referred to the paragraphs which implicates him in the statement. He thought that he was entitled to the entire statement and annexures, but that was clarified to the Ramate CA. Subsequent to that, Mr. Chair, there was any correspondence that was received, and we know that he was also favored with a 3.3 notice.
Do we know whether there might not be another Mr. Ramate that was meant?
No, Mr. Chair, because if you look at the last paragraph, it's quite revealing in a way to say that,
Yes.
well, he admits that there was that entity.
Yes.
He might only contest the
Yeah.
name in which it
Yes.
was placed in the statement.
Yes.
But at the end of the statement, you find
Yes.
that he said that, well, by the way, there
Yeah.
is this one which I think that Mr. Dukwana might be referring to.
Yes,
Those
okay.
will be dealt with accordingly with Mr. Dukwana.
Okay.
Mr. Chair, then if you go to folder number 4, it is with reference to a party referred to as Musidi Mutsimme, who also reacted, and he was.
I'm sorry, you said.
Folder number 4.
Or is 36 duplication of the earlier one? Or is it the one that we were looking at?
No, we were looking at folder number 3, which is relevant to Ramate, CA.
Yes, but I see 36 is also Ramate CA.
Yes,
Is 36?
it is duplicated.
Oh, it's
It is the
duplicated.
same thing, yes.
Okay.
It is
All
the
right.
duplicate, Mr. Chair. If you turn to folder number 4, and that is page 43, it is correspondence dated the 5th of August 2019, which was received from the attorneys Victor Nkwashu attorneys, who are acting on behalf of Ms. Musidi Lydia Mutsimme. And they record, Mr. Chair, that we refer to the above matter and advise that we act on behalf of Musidi Lydia Mutsimme. Our client has handed to us a notice in terms of 3.3, wherein she was advised that Mr. Dukwana will be presenting evidence which might implicate her. We wish to place it on record that in order for our client to fully exercise her rights and to make a choice on what action to take, she requires the full evidence of Mr. Dukwana in order to give context. Clearly, Mr. Chair, they also wanted a full statement and annexures. So paragraph 4, it says that the statement our client has been furnished with contains at best an incomplete statement. Just by way of an example, paragraph 95 of the statement ends with an incomplete statement which starts with the words, I am not sure if Mutsimme. And in paragraph 5, our client is therefore unable to exercise the rights without the full statement of Mr. Dukwana. Kindly furnish us with the full statement of evidence as a matter of agency so that we can consult with our client and provide her with sufficient legal advice on this matter. We trust that you will find the above in order. That was reacted to by the Commission, Mr. Chair, on page 46. We will not read the contents. It's simply, we clarified the question that they are not entitled to the full statement, but they were nonetheless given the full paragraphs of the full paragraph 92 to 95 of Mr. Dukwana, which was annexed to the letter. Subsequent to that correspondence, Mr. Chair, there was never any other correspondence from the same attorney, and you can only say this to the best of our knowledge.
So there were 2 pages that were considered to implicate her.
Yes.
And those were provided
They were provided, Mr. Chair.
on the 13th of August.
Definitely. And subsequent to that, and they were given to the attorneys
Yes.
in advance, long in advance, so that they can react or
Yes.
choose what course they wish to adopt. Mr. Chair, then you have the folder number 5, and what is relevant, Mr. Chair, is what appears from page 55 when the party wished to place an affidavit, and it's Hansi Betilda Matsike. And in that statement, Mr. Chair, she repeats the notice which was dispatched to her. She also, on page 56, repeats the documents supplied to her by the Commission. And on paragraph 3, she then repeats the paragraph which is said to be implicating her or may implicate her. And she gave a history on page 57 about the VDC chairmanship and related matters, Mr. Chair. I'm doing this because I've read it. It's not relevant for what ought to be canvassed, but on page 58, she gave the construction of the company and the alleged conflict of interest in the Friede 1000 project. And what appears to be paramount, Mr. Chair, is on page 60 in relation to paragraph 7, where she says that I've perused the NHBRC form in relation to the entity known as Unital Holdings Pty Ltd, in particular pages 213 to 216 of the annexures of Mr. Dukwana's statement, which the Commission referred me to, and I do not have any response, as these documents have nothing to do with me or any of my entities. I am also not related to persons mentioned in this document. The next paragraph, she says, I have also perused the CIPC documents in relation to the entity known as Unital Holdings Pty Ltd, in particular pages 217 to 219 of the annexures of Mr. Dukwana's statement, which the Commission referred me to, and I do not have any response, as these documents have nothing to do with me or any of my entities. I am also not related to persons mentioned in this document. Next paragraph, since Mr. Dukwana's allegations against me are limited only to paragraph 75 of his statement, I have therefore limited my response only to paragraph 75 of Mr. Dukwana's statement. Should Mr. Dukwana give evidence, which is not part of his statement under reply, at the Commission, and which evidence implicates me or has the potential to implicate me, I reserve my right to proceed, of course with leave from the chairperson of the Commission, in terms of paragraph 5 of Rule 3.3 notice, read with Rule 3 of the Commission's rules. Against the above background, at this stage, however, I do not intend to proceed in terms of paragraph 5 of the Rule 3.3 notice, Mr. Chair. That is the essence of what was conveyed to the Commission by that affidavit, Mr. Chair. The next correspondence, we find it on folder number 6. It appears from, it was dispatched by Melanie David Incorporation, and it's a simple statement that is being made on page 78, Mr. Chair. They are representing the Director of Master Trade 232 Pty Ltd, that is Mr. Melan David. They say that I have received the notice, but please note I am not the Director of Master Trade 232 Pty Limited. This was a shelf company that was formed by a company I worked for 20 years ago, and I resigned when the company was on-sold to a client. I have attached a current CIPC printout of the company showing my resignation date as 26 October 1999. I have no knowledge at all of this company. Kindly acknowledge receipt. That's all that was conveyed. And with reference to folder number 7, Mr. Chair, it is a letter by Mr. George Fivers. That letter, Mr. Chair, it starts from page 84. It's dated the 19th of August, 2019. We are not going to read that letter into the record. It's a long letter, but the reason also is that it implicates a number of individuals who were never favored with any notice nor being made aware of the contents of this letter. But the long and short of it, Mr. Chair, is that Mr. Fivers alleges that he was aware at some point that his company was used in the Free State in order to fabricate some of the reports. But he says so with reference to particular names of individuals who were unfortunately not favored with 3.3 notices, but he has also extended an invitation to the Commission that he is prepared. If you look at page 89, Mr. Chair, he says that I am prepared to provide a sworn affidavit and verbal evidence under oath to the Commission to confirm the above stated facts. That will also in due course be dealt with and properly be placed before you, and a statement being obtained from him in that regard. So we simply don't wish to read that letter in order to avoid implicate people that are implicated who may raise serious objections to that. And in all fairness, we think that it's a prudent way to deal with it. The other correspondence, Mr. Chair, is the one on folder number 8. The dates are quite important, Mr. Chair. It's the correspondence from Maharaj attorneys who are representing, as per their letter dated 20 August 2019, the implicated party, Mr. T.W.
That's starting
Zulu.
at page what?
Page 106, Mr. Chair.
106.
106. It is the
Yes.
letter from Maharaj attorneys dated the 20th of August 2019, which was dispatched to the Commission and for the attention of the Commission, which you must bring to your attention, Mr. Chair. It says re-implicated person, TW.
Is that the one where preferably the name should not be mentioned at this stage of the person?
That's what
I think
Mr. Helens prefers.
Maybe for now, let's do that, and then when I've had everything, we can take it from there.
Well, Mr. Chair, without mentioning the name,
Yeah,
the client of Mr. Helens,
yes.
and you'll see that there was the first correspondence that was dispatched on the 20th of August 2019. I'm sure that I can mention the name of the attorneys, Maharaj attorneys.
Yeah.
Paragraph 1 says, Mr. Chair, I refer to the above matter and record that I have been consulted by, I won't mention the name, an implicated person arising from the contents of the affidavit filed before the Commission by Mxolisi Dukwana. I am awaiting receipt of further instructions from client regarding his election under Rule 3.3.6 of the rules, and will revert in this regard imminently together with an application for condonation. So this letter, Mr. Chair, was sent as it is on the 20th of August 2019.
Yes.
And on the 23rd of August 2019, page 108, Mr. Chair, I don't want to lose you. And it says that paragraph 1, it's from the same attorneys, Maharaj attorneys, dispatched to the Commission. We enclose herewith the response by our client, and the name is mentioned, to the Rule 3.3 notice. Although the notice was served by email on the personal assistant of the client on the 5th of August 2019, the client was at the time on sick leave. He only returned to work on the 12th of August 2019. Although indisposed to illness, he made efforts to obtain legal representation. The firm advised me that allegations were so serious that he should take advice from senior counsel. 4, the firm accordingly engaged the services of Mr. Michael Helens SC and Mr. Shane Dial SC to advise client. Obtaining legal representation also required Mr. Zulu, who is but obtaining legal representation, it's going to be difficult, Mr. Chair, also required client who is but an individual to raise sufficient funds to to finance the legal representation necessary. All of course client not to be able to respond within 14 days, provided for a response which 14 days presuming would run from 5th August 2019. We hope that you will note that notwithstanding being ill, he commenced efforts to obtain legal representation and finally did obtain legal representation, having scrapped together the finances thereof. This response, which is in one sense late, but in a real sense a responsible response, was made as soon as the circumstances allowed it. We trust that this late response will not be seen as a reason why the evidence proposed to be led and foreshadowed in Rule 3.3 notice will nevertheless be led, notwithstanding the very clear evidence of client contained in the affidavit annexed here too. Senior counsel is available to engage the Commission on urgent basis, and in any event will attend at the Commission on Tuesday and to make public comments of client to ensure that his reputation is not unnecessarily tarnished and he is not defamed. We trust that the Commission will take the contents of client's affidavit annexed hereto very seriously. Indeed, there is every reason given to the contents of the statement of our client for you to exercise the discretion that you have under the rules to postpone the proposed leading of his evidence pending a more responsible investigation by the Commission of the contents of the affidavit of client. And it was signed by Mr. Maharaj, Mr. Chair, and annexed to it is the affidavit of client. Mr. Chair, starting from page 111, 111, and the essence, Mr. Chair, of the affidavit, and I'm sure that Mr. Helens will, in much more able ways, place it before you, but the essence of it, Mr. Chair, is that the name that is appearing in the spreadsheet annexed to Mr. Dukwana's statement with those initials do not refer to this client, and therefore that this client did not take part or participate at all in the asbestos saga, and he never even received any amounts in that regard. I'm simply summarizing and paraphrasing, which I think is the highlight of the statement. There might be other statements which, depending as to how Mr. Helens deals with them, which we may wish to respond to in due course. But for now, we'll leave them and simply deal with these proceedings with the integrity that it deserves, Mr. Chair. The next one, Mr. Chair, it's folder number 9. It was not properly, put in a folder because this correspondence kept on coming in even today in the morning, Mr. Chair, but we tried to do our best to collate all the documents and to make sure that we place whatever necessary information and those correspondence before the chair.
Is that the divider marked N rather than 9?
Chair?
Mine is marked N, not 9. The next one after
I
8.
know, Chair, and it is because it was simply dealt with within this hall, and as correspondence was coming, and we also saw it for the first time.
Is that the one immediately after page 1, 2?
If you go
3?
to page 124, fortunately they are paginated, Chair.
It starts at page 124.
124.
Okay.
And if one traces, this is the correspondence in relation to, I don't want to say it's Mr. or Mrs., and I'm wrong, Mr. Chair, but the same name I can see that is Mr., I think, Kupang Franz Raleigh Kontsani. And as you can see from the dates, Mr. Chair, appearing at the bottom,
I can't see the name that you are.
if you go to page 124, Mr. Chair.
I am at 124.
And then you look at the second sentence. This is an application for leave to give
yes.
evidence brought by. So that's
Yes,
where
yes.
I thought that one should derive the name.
Yes.
Mr. Chair, to the best of what one can ascertain, despite the submission that we made that it was clearly a Rule 3.4 application and which was finished in terms of the rules, simply by glancing at the date, you'll see, Mr. Chair, that it was dispatched to the commission, if I'm correct from what I'm reading. Is it on the 23rd? On the 23rd, Mr. Chair, we may be corrected, but that's what we have before us. And if you go to page 124, it's simply between the lines. It says that the statement in support of 3.3 for leave to give evidence, disputing certain portions of the evidence of the witness, Mr. Mxolisi Dukwana, to testify on the 27 and 28 August 2019. I don't wish to be technical to the extent that we are called upon to read this as a 3.4 notice. So, Mr. Chairman, we'll put before you as that it is a
just
rule.
that the document doesn't even have the date when it was signed.
Yes, it doesn't have what prayers one would seek, lining them with the 3.3 or 3.4, but we don't want to be that technical. If you go to page 150, Mr. Chair.
Well, he does say he seeks leave to, is it he or she?
He
does say he seeks leave. It's an application in terms of Rule 3.
To give evidence, disputing
for leave
certain.
to give evidence.
Yes.
Yes.
But it is signed. It appears that if you go to page 157, Mr. Chair, I think it was signed. It says that that's signed at Bloemfontein, 23rd August 2019.
That is at what page?
At page 150. It appears to be signed on that date. At least there is a date, Mr. Chair.
Is that the end of the affidavit?
It's 150. Because at 151, you then find the signature of Mr. Ralekontsani.
Oh, yes, the affidavit.
Yes. So
Well, is it
signed.
an affidavit or just a statement? Looks like just a statement.
Yes.
Was signed on the 23rd.
It's
of
a statement.
August.
That's why we are saying that we are not sure that it's an application as
Yeah.
provided for in the rules, and we know what Rule 3.4 of the Commission requires the party to do, Mr. Chair. And that is the
Yes.
reason that we simply say that it was a statement in reacting
Yes.
to the contents of the statement of Mr. Dukwana, rather than it being a Rule 3.4
Yes.
application. We can leave it at there. Mr. Chair,
Yes.
we can also mention that a number of these documents and correspondence that we have actually put before the Commission, we have not had time to even put them before Mr. Dukwana and his legal team for them to accordingly react. But we just thought that in fairness to the parties that might have actually endeavored to place them before the chair, let's do that. As to how we are going to deal with them in these proceedings, that will be something to be directed by the chair in due course, having had submissions from different parties. The last one, Mr. Chair, that I also saw for the
Yes,
first.
that one ending at the affidavit of, or the statement of Mr. Ralekontsani, they should find it quite easy to convert it into an affidavit.
Yes.
Yes, okay.
Yes. The last one, Mr. Chair, if I'm correct to say that is the last one, because documents kept on coming, and there was a late reaction to the statement of Mr. Dukwana, is to be found in the last folder. I'm even not confident enough to tell you whether it's folder number 10 or what folder it is, because they were all prepared today.
Well,
but
I
at
have,
least page 183
I have
might give us guidance.
a divider which is preceded by page 183.
Yeah.
It's not marked 10. What it is marked is either 0 or O, one of the two. If you put 1, it will be 10.
Mr. Chair, it's page, if I may refer the chair to page 183, I hope that
Yes,
it will accord with our pagination that I'm having.
yes.
This is the correspondence which we received. It contains the statement that is on page 187, Mr. Chair. That statement, or it's an affidavit, let me just, it's a statement, Mr. Chair, by Blakey Siwe,
Yes,
and it's simply a reaction to Mr. Dukwana's statement pursuant to the party having been finished with a Rule 3.3 notice, and he simply finishes his own version in that affidavit and attempts to also deal with the paragraphs that relate to him in the manner that he did from pages 191.
yeah.
We have also not had the opportunity to properly apply our mind to these documents, to
Yes.
place them properly before Mr. Dukwana and his legal team for them to react. As you know, Mr. Chair, that we have no version as the commission, but the evidence that we lead is the one that is from the witnesses, and those witnesses, all of them, are the witnesses of the commission.
Yeah.
Mr. Chair, those are the correspondence that we have received in reaction to Mr. Dukwana. We are ready to proceed leading that evidence, but I'm sure that before we do that, there might be the parties, as we have indicated, and as we might have heard in chambers, that who may wish to make certain submissions before we proceed.
Yes, from what transpired in chambers, I understood Mr. Helens to be the one who may wish to raise some point, and depending on what he has to say, there may be a need for responses. If there is someone else who has another point that does not relate to the point that Mr. Helens wishes to raise, then I will get to know after Mr. Helens, and after we have dealt with the point that Mr. Helens wishes to raise. Yes, Mr. Helens.
Thank you, Chair. Chair, you're aware of the client that I represent, and the simple proposition that we place before you is this. We don't know whether you have had sight of the evidence that this witness intends to give, and we don't officially know whether you've had sight of the response that our client has given.
Well, I have had sight of the evidence that this witness will give. I didn't have sight of the statement from your client as yet,
Mr. Chairman,
until it was pointed out now.
Sorry. Let me break it up into 2 points, which are foundation for the address that I want to make, or perhaps 3. Firstly, it is incumbent upon this commission, given the sacred duty that it has, to investigate responsibly, to present evidence which needn't be cast iron in nature, but must not be wantonly speculative. As I stand here, you and I are on national TV, and the allegations about my client will be nationally publicized all over. You, as the guardian of the reasonable conduct of this commission, solely responsible therefore, have to ensure in our submission that wildly speculative evidence is not placed before this commission. Even if my client were to be given the right of cross-examination and demonstrated to be untrue, the harm is done by leading speculative and unmeritorious evidence, prima facie so. Now, what we say is the allegations with regard to our client, and let me make this point, it is specifically the allegations made about our client, not the general topic. We have no objection to anything said by this witness on the general topic. But when his statement focuses in at one moment, at one point, on an allegation identifying our client as responsible, it is blatantly speculative, it is unsupported by any documents, and the document as a whole, by the way, but we're not concerned with the documents as a whole, is like a running scandal sheet of a person 3 times removed from the facts. Now, whether you want to hear that evidence with regard to other people is up to you.
Hang on, Mr. Helens. I think it would be better that I read your client's statement first.
I was just going to get to that.
Because I think you might or might not need to persuade me much.
Yes.
Depending on what
My Lord,
I take of the matter. But I'll follow your argument much better if I've had a look at it.
let me just say what I expect that you will find. You will find that in concrete form, my client denies any involvement. He says, no one has asked me for a version before, no investigators have interrogated me. I tender my bank statements, I tender a complete investigation by the commission with myself personally in attendance, and all I ask is that before you ruin my reputation and my career, you postpone this evidence, not as a whole necessarily, but with regard to me, and investigate this case properly.
The identification.
Yes.
Basically.
And we go on to say that it's recklessly gathered with regard to our client, and I say this with the deepest humility but the utmost strength. There are consequences to this commission acting unlawfully and recklessly, and we will, let me stop there.
Well, as I say, I haven't read his statement, but if it's going to be of any help in how we deal with the matter, I would be inclined, and I haven't read the statement, I would be inclined to say to the Commission's legal team and Mr. Dukwana's legal team, how much have we done to try and make sure that the identification is reasonable?
Yeah, reasonable.
Maybe that's not the correct word, but that's the word that comes to my mind immediately.
The product of a reasonable...
It's not certain, it might not be certain,
yes,
but that it's reasonable. And if the answer is it might be better to get more time to do further efforts, my inclination would be to say, well, why don't we allow those efforts to be made first? And at the end of those efforts, then we can hear whether the identification that was intended to be made will still be made. And if it will still be made, it may be that it should be allowed at that stage. But in case the further efforts at confirming the identification reveal that it's not correct, it might not be made. That would be my inclination. But I say so, I make that inclination known without having read your client's statement and without having compared it with what Mr. Dukwana says. I do I did see your client's name somewhere,
Yes.
and I did see how it was, what was said about it. So that's my thinking. Maybe I should hear what Mr. Dukwana has to say and what Counsel for Mr. Dukwana have to say, and depending on what they have to say, we might have to adjourn and let me read, and then we come back.
You have the essence of my submissions in the cup of your hand, Chair.
Yes, thank you. Who should come first? Or you, Mr. Dukwana?
Mr. Chair, there's protocol at the bar. Mr. Chair, may I?
Mr. Dukwana's counsel will get a chance to stand up.
knows,
He might
Mr.
respond.
Mr. Chair, we are inclined to follow the Chair's approach and advice, but let's do so in a far much more responsible manner. We are not doing this because of fear of any threats that might be leveled against this commission, or maybe being intimidated that when we lead evidence, there might be consequences. We are simply doing that in order to assist the furtherance of the mandate of this commission, not because of any fear. We are called upon to deal with the evidence that is received from any witness without fear, favor, or prejudice, and not to treat any of the witnesses in any special manner. But we are mindful that the Chair might not have yet read the affidavit of the client of Mr. Helens, and to that extent, maybe it's a responsible thing to afford you that opportunity to do so. Mr. Chair, that's all that I wanted to say for now.
So is your position that you would prefer that I read the statement stroke affidavit first before?
Yes, you may do that, Mr. Chair, but that should not delay the leading of the evidence of this witness.
Yes.
What we can do,
Yeah.
while you're still going to read, we can lead Mr. Dukwana's evidence.
Yes.
And to the extent that we might be coming at that portion,
Yeah.
maybe then the Chair might direct so that we don't waste any time unnecessary.
Yes.
Yes.
When do you expect Mr. Dukwana might come to that? So, I mean, based on what you are saying, one possibility is that he would not, if he comes to the relevant part of his evidence, he would skip that part, which is a very limited part, as I
Very
understand.
limited, Mr. Chair.
He would skip that part.
Yes.
And if he skips that part, it might, if it comes up today and he skips it, it might mean that tomorrow.
Tomorrow we might have to deal with it, depending on how you deal with
Yes.
yes, Chair.
Then of course I would have read it by then. The only difficulty with that might mean that Mr. Helens' client might have to bring back Mr. Helens and the legal team tomorrow, when maybe we might have finalized everything today.
Yes, Mr. Chair, but I mean, that we are
Yes.
doing in order to cater for
Yeah.
his client's interest. And we are doing so because we're prepared to lead evidence on all the issues and the topics of Mr. Dukwana. But having listened to Mr. Helens and having listened to the Chair's approach in this regard, it might be a sensible thing to do. And I'm not...
I got the impression, when I had a look at at Mr. Helens' client's affidavit, as you were speaking earlier, it looked like it might be something like 7 pages. Is that more or less?
It's a very short
It's a
affidavit.
short,
It's a
yeah.
very short affidavit.
So it may be
6.
that if I were to take an extended tea break, I
Yes.
might be able to.
You might be able to read it, then
read
I
it.
might also have to lead Mr. Dukwana without any interruptions.
Yeah.
But I'm sure that maybe my
Yes.
colleague, Mr. Smanga, might want to say something on this.
Yes. Let me hear.
Chair,
Yes.
we also want to place it on record that Mr. Dukwana is here to advance the constitutional mandate of this commission. He's here without fear or favor. And under no circumstances should this commission treat anybody with kid gloves. We are in concert with Mr. Mokoena that the chair should be afforded an opportunity to go through the statement, after which the chair will be in a position to listen to the submissions that will be advanced by Mr. Helens SC with Mr. Dial SC. And then certainly we stand ready to make our submissions.
Yes.
And we do not want a situation where this commission would hear the evidence of Mr. Dukwana interrupted. We want the coherence in his statement to be what is captured in the statement. And in that regard, an extended tea, we are in concert with that. But before that, it appears that Mr. Lebala SC wants to address you, Chair.
Okay. I'm sorry, is Mr. Lebala coming on the same issue?
Mr. Chair,
Oh,
may I
think
just
let-
say that I agree
Yes.
that you should look at
Very
our
good.
statement,
Yes.
make a decision about that.
Yes.
And just to make a point I may have already made, we're not trying to stop the leading of this witness in
Yes.
total. It's just, if it's considered that more research with regard to our alleged involvement is necessary,
Yes.
he can be led without that portion.
Yes, yes. Thank you. Mr. Lebala?
Esteemed Chair, there's an incremental issue coming out of what you have heard, particularly from our learned friend, Mr. Mokoena. We don't want to deal with the granularities of the rules, Chair, but there are dire straits created by our statement which is standing before the Commission.
Yes, but you're talking about your statement. We are still talking about Mr. Helen's client's statement.
Well, accompanying that is the fact that the Commission would be assisted if our statement is also given to the witness, because our statement sheds light about a version of our client, Chair. And all inclusively.
Yes,
I-
but what has that got to do with the identification of Mr. Helen's client? Because that's what I'm dealing with.
It's a separate issue, Mr.
Yeah,
Helen's
but I
client
said,
is-
let me finish
fair
the
enough.
issue relating to
Fair
Mr.
enough.
Helen's
Fair
client.
Fair enough.
Yes.
Fair enough.
Okay, all right. I think I will take an adjournment. It is 11:15.
Yes, Mr. Chair.
11.
Yes.
Mr. Mokoena, is there anything you want to say
No,
before
no,
I take
Mr.
the
Chair.
adjournment? Nothing.
Yes.
I'll take the adjournment. It will be longer than usual, so I can get the chance to read. I'm going to resume at 20 to 12 instead of 11:30. But if I haven't finished, I might resume a few minutes later than that. We adjourn.
Sorry, Chair.
Yes.
May I suggest that in the meantime, perhaps it will be prudent that the Chair is favored with our supplementary statement, because that statement is going to give the context in,
On the identification.
yes, in Mr. Helen's statement.
Oh,
Yes.
okay.
Mr.
I
Chair,
think
we'll
you
do that
you
in-
mentioned that there was still some
Yes, Mr. Chair.
supplementary statement. Does Mr. Helens have that because it
no.
might put a different picture to?
Mr. Chair, we'll make sure that you receive it within the next 5 minutes. Maybe we should resume at 12 o'clock to allow that opportunity.
Yes, maybe because Mr. Helens if he hadn't received it, he might want to have a look at it as
Yes.
well. But shall we make it, how long is the supplementary?
How long is it?
Chairperson, it is only 4 pages to
About
4 to
four.
5 pages.
Yes.
It accompanies the very same email correspondences that are in issue,
Yes.
which are the basis
Yeah.
of the contention of Mr. Helen's client. So,
Okay, all right. I think let me Mr. Helens, I see you want to say something.
Mr. Chairman, we were given a Rule 3.3 notice. We responded to it. We are
Yes.
told at the last minute that there's supplementary evidence.
Yes.
We understand now it would be in response to what we responded. This is the
Yes.
first moment we hear of it.
Yeah.
It's untenable. It's unacceptable.
Yes.
We can't just be bulldozed into rolling over now with a surprise statement produced. What's supposed to happen with a responsible investigating body is you interrogate people, maybe under summons, maybe under voluntary submission, which we would have done. You develop a sober attitude towards one set of evidence as against another. You investigate it properly, but you don't on the day allow a witness to do a supplementary statement in answer to a considered statement by us and then ask for a ruling on the day. We need an opportunity to respond.
Yes, no, you will need to have a look, but I think let's let the adjournment go up to 12, and then at 12 I'll resume, and then we'll then see what we can do or how far we go.
As it pleases the chair.
Okay, we'll adjourn.
All rise.
I've had the opportunity of reading Mr. Helen's client's affidavit, as well as Mr. Dukwana's supplementary affidavit. I was unable to find anything in Mr. Dukwana's supplementary affidavit that relates to the identification of Mr. Helen's client. And as I sit here, my inclination is to say we continue to seek to strike a balance between ensuring fairness to implicated persons, but also ensuring that as far as possible, we are not unduly hampered in the work that the Commission has to do. My inclination is that where we are dealing with a person who says, before you mention my name publicly in regard to something like this, I'm here, I'm cooperating, you haven't spoken to me, come and speak to me, and I will cooperate. My inclination is to say, if the Commission hasn't done that as yet, it should rather do that. And if at the end of that exercise, the position is still that the position doesn't change, then one can take it from there. But you might well find that the position changes, in which case it could make a difference. It doesn't appear to me that there would be much prejudice to the Commission if we were to go that route. So I don't know if you want to say, that's not a ruling yet, that's an inclination.
Yes.
I don't know if you want to say anything, Mr. Mokoena.
Mr. Chair, only if that invitation was made much more earlier. You have seen that it was just made on Friday. We are aware that paramount to this Commission's proceedings is, the concept of fairness. And one would want to ensure that all the parties are afforded sufficient time to react to whatever statements that might be made, against them, or evidence that might be led, which might implicate other people. So we are much more inclined to adopt that approach, subject obviously to what Mr. Simanga Sisitini might want to say, and subject to what Mr. Helens might want to convey to the chair. If the evidence has to be led, it will be led. If we have to apply to be cautious to it, we will do that exactly.
Yes. Counsel for Mr. Dukwana.
Thank you, Chair.
Yes.
We believe the Chair has read the supplementary.
Yes, I have, yes.
In the preparation with client, together with the legal team of the Commission, this issue of abbreviations of names was articulated by Mr. Dukwana, giving context to his contention in his statement, saying why SS is Manga Sitini and PM is Philip Mokoena. Besides, Chair, anyone who comes before this Commission that SS should not be stated and challenges the fact that SS means Manga Sitini, and the chairperson finds that there are publications like this book, where the very same or a similar contentions are advanced by the author. What Mr. Dukwana is bringing to the commission is simply evidence to say there was this email correspondence between directors of companies who benefited from asbestos heist, as Mr. Dukwana terms it. And it is those emails that will put PM at the scene. And what Mr. Dukwana does not say in his statement, he does not say definitively that PM certainly means Philip Mokoena. He says, PM, it is believed to be Philip Mokoena, who at the time of this project was at the helm. Now, if I were to take Chair to this book, right, which was published, if I'm not mistaken, last November, and then PM is stated there, and a reasonable reader comes to a conclusion that because PM was at the helm of a certain department at the time, a reasonable person will come to a conclusion that indeed PM could be believed to be Philip Mokoena. That's the contention. Now, I do not see how this commission's work is going to be hampered, even if we were to go by the abbreviated version to say it's PM.
I'm sorry. I didn't understand Mr. Helens to object to the mentioning of certain initials. My understanding of his objection was anything to say those initials refer to his client. I think that's my understanding.
Correct.
It's not my understanding that your client should not say, well, this document refers to that, but his concern is anything to suggest that those initials refer to his client.
That is why, Chair, I'm saying there is nothing wrong with this commission continuing with its work. When it comes to Mr. X, it would say, let's call him Mr. X throughout, and then say why, Mr. Dukwana will say why he believes indeed Mr. X is at the scene of the asbestos heist, as he puts it. There's nothing wrong. In various cases in High Court and elsewhere, where person's name, it is contended that it should not be mentioned, they've been referred to as Mr. X. So that is the contention.
Yes.
But the Chair would note that the affidavit of Mr. X, let's call him Mr. X, does admit that he was at some point at the helm of a specific national department. It does not say whether Mr. X is known to the late director of that a certain company and to another implicated person. Further, Mr. X does not say in his statement whether whilst he was at the helm, at no stage when he was chairing a meeting, let's call it a technical min-mac, there was never a presentation relating to this, of this magnitude relating to asbestos in the Free State. There is a context why Mr. X, according to Mr. Dukwana, is placed there. And Mr. Dukwana is going to elaborate that, and Mr. Mokoena would also attest to the fact that it was an issue, even at the preparation of the statement, to say, why are you saying this is Mr. X? And why are you saying this is Mr. Z? Or why? And all of those names, as articulated in the statement of Mr. Dukwana, are explained.
Well, it may be that some people who may be mentioned haven't made the same offer that Mr. Helen's client has made and committed to cooperation and so on. But it seems to me that further engagement with him, including an interview of Mr. Helen's client, might well reveal, he might be asked, were you at that meeting? You have just mentioned a certain meeting. He might say, yes, I was at that meeting. That may or may not fortify the belief that Mr. Dukwana may be having, that the person referred to by certain initials in the correspondence is Mr. Helen's client. So my inclination is there is no harm and there may be benefit in that further engagement. And at a certain stage, Mr. Dukwana can come back and say, well, the further engagement and the further investigations have actually fortified me in my view, and come back and say I can really support why I say this is Mr. Helen's client. Or he might say, having been shown what has been unearthed in the further investigation or engagement, I do not persist in saying those initials refer to so and so. So in other words, if that part of identification is to be dealt with later, the Commission doesn't lose anything because it will still be dealt with. And it may be that the further engagement will confirm that he was right he's right in his belief, or it might show that maybe there are no proper grounds to give that identification. That's my inclination.
Chair, if that is a chairperson's inclination,
yeah,
then I would propose that let it be extended to all persons who appear in the statement of Mr. Dukwana in the abbreviated version. Because some of them are here and they are not making any song about the abbreviated version. All what they place themselves on the record to say we are for certain persons. So if that is the chairperson's inclination, I'll propose that it be extended to all persons, even if it means that those paragraphs where those abbreviated names appear are blacked out, or for the sake of fairness, they are retracted so that they are to be placed at a later stage when Mr. Dukwana comes back. I don't know if Mr. Mokoena disagree or agree.
Mr. Mokoena. You said Mr. Dukwana, you meant Mr. Mokoena, I think.
No. I know.
You looked at Mr. Mokoena. and said Dukwana.
It's a voice from behind. In fact, I'm happy that Mr. Helens is very happy with my proposals, Chair. And he's going to come and agree with everything that I said. Thank you, Chair.
No, before you sit, the position is that, as at least at this stage, I've only been informed of Mr. Helen's client's objection. No one else has expressed any objection. Different people take different approaches to issues. Another person might say, look, as long as I'm going to end up getting a chance to cross-examine Mr. Dukwana about what he wants to say about me, it's fine, I'll deal with him in that way. Or I will give evidence and it's fine, let's proceed, But somebody else might take the attitude that Mr. Helens has taken. But having said that, if Mr. Dukwana feels that he would rather not proceed to mention certain names at this stage because he feels there may be a need for further engagements in the same way as in regard to Mr. Helen's client. That's something that he might need to raise with Mr. Mkwena, and of course you would be there, and then we take it from there. But as I say, some people would have different approaches to issues, and just because I have a particular inclination in regard to Mr. Helen's client doesn't necessarily mean it would be the same inclination to others, but I don't know. Each one would need to be, I would need to be informed of how, for example, with regard to Mr. Helen's client, it's initials that are there. And Mr. Dukwana says, in effect, I believe those initials represent so and so. But I think I have seen, if I'm not mistaken, some names that are given in full. I may be mistaken. So it may differ. But I'm sure if they are here, they would be able to speak for themselves. But to the extent that you might say, on behalf of Mr. Dukwana, you would prefer that he doesn't mention certain names, I would allow you and Mr. Mkwena to discuss that, and then we take it from there.
In that regard, Chair, I think we will have to take instructions also to Mr. Dukwana, from Mr.
Yes,
Dukwana.
that's in order.
It would mean
Yes.
a short adjournment would be fitting.
No, that would be fine.
Thank you, Chair.
Thank you. I think I don't know if I saw Mr. Helens wanting to stand up.
Just, my learned friend has gone very far, sailed very close to the wind of revealing what he shouldn't. But having said that, we are fully in accord with the inclination intimated by you, sir. I think PM agrees. We would just ask, for formality's sake and procedural sake, if the supplementary affidavit is an affidavit that the Commission wants to put to us under Rule 3.3, they must decide to do that. And secondly, if they want to see our client, then we must just make an arrangement. And then lastly, in accordance with your inclination, it's obviously not only the name of my client, but the designation which goes with it, because that identifies it. So I don't have to say, don't say Zondo, but you can say the chairperson of the Zondo Commission. Well, that would be defeating. So it's 52.3.1. It's that entire description. But apart from that, we are in accordance with your indication.
Okay, thank you.
Mr. Chair, all this does violence to my preparation, but it's fine, we'll adjust accordingly.
Yes.
The only thing is that we should be cautious not to invite objections which were not there before. The objections that we have formulated are the ones for the client of Mr. Helens, and we have them on paper. I don't have any other objections, and we have indicated that the Rule 3.3 notices were
Yes.
dispatched timelessly, and if there was any party that was wishing to react,
Yes.
it could have done
They
so
would have done
within the
so.
year. So for
Yeah.
now,
Yeah.
I'm comfortable that we can lead the evidence
Yes.
with simply without referring to Mr. Helen's client's
Client,
name.
yes.
Even if he may ventilate as to why it says there, but we can definitely make sure that we don't say that,
Yes,
mention the name and the designation.
yes, yes.
Chair, if there's just one more thing. Perhaps if I didn't make myself clear, if you use the initials in the total context, that might identify the person. So it should be not the initials and not the name and not the designation.
Well, as I recall, the document to which Mr. Dukwana refers bears certain initials.
It does.
Now, on the face of it, I don't see anything wrong with Mr. Dukwana saying that document on that part mentions these initials and stopping there.
Perhaps that's the only practical way
Yeah,
out,
yes, yes.
as the Commission pleases.
Yes, yes. Thank you. I think Council for Mr. Dukwana might be wishing to have some
Take
discussion with you, Mr.
instructions.
Mkwena.
Yes.
We are at 23 minutes past 12. Maybe you don't need more than 5-10 minutes?
Or Chair, we can do it the other way around.
Uh,
We can take the early lunch adjournment and come back at 12:30.
Yeah, I
Instead
thought
of-
of that, but
in-
I'm thinking that you probably wouldn't need more than 10 minutes. And then maybe if we take about 10 minutes, maybe then we could have about 25 minutes before the lunch.
And
You
we can
could
proceed,
take
yes.
Mr. Dukwana through certain portion, and then we take lunch at the normal time.
I'm at your hands.
Yes. Okay, we'll adjourn now and resume at 25 to 1. We adjourn. Yes, Mr. Mkwana.
Mr. Chair, maybe it will be opportune to afford my learned colleague to put the instructions of client, and we will, in either way that they deem it necessary to proceed with the matter, we are ready to do so.
Thank you.
Thank you, Chairperson.
Yes.
We have consulted with Mr. Dukwana. He says we must place this on record, that there are other witnesses who came before the commission. They mention certain names of persons who, prior to coming here to testify, and he sees nothing really special about certain witnesses or a witness why he should be treated differently. He makes reference of the fact that the former president was here. He made mention that retired General Spiwe Nyanda was a spy, and that process is out there, ventilated in the courts. Why this particular one should not be treated or be given the same attitude. In addition to that, he says in any case, the list is out of persons implicated, and all their names were read out. And unfortunately, there's also been a slip of the tongue. And we live in a technological world. It now becomes moot. The identity of Mr. X becomes moot, because it will be headline news in any case.
Hang on one second. I note that as you place what you are placing on record, Mr. Helens is no longer here.
Correct, Chair. Now, we are in your hands, Chair, with regard to that. Perhaps it's a discussion that we would have to have with Mr. Helens, together with the legal team of the Commission, to say, in the light of this, what are we doing? Because I can tell you now, Chairperson, it may be now trending on the social network as to who is this Mr. X and why the identity of Mr. X has been concealed by the Commission. And it places the Commission in a serious predicament as to how is it going to deal with other witnesses moving forward. Because the inclination of the Chairperson certainly opens floodgates of other witnesses wanting to go the similar route that Mr. Helen's client has advanced. This, I'm not sure if the Commission as well is also inclined to hear evidence of Mr. Dukwana in a piecemeal fashion. And I doubt it will be desirable that evidence of Mr. Dukwana is heard on a piecemeal basis. Perhaps, Chair, it will be prudent, as Mr. Mkwena proposed earlier, that let's take an extended lunch, and then Mr. Mkwena would contact Mr. Helens to request him to do a U-turn. And failing which, we may have to meet later with Mr. Helens and Mr. Dial to explore this matter, because otherwise the Commission is going to be said to be a mummish in a sense that...
Well, let's look at this. Well, one, you say your client mentions the fact that the former president mentioned certain names.
Yes.
Now, the former president had not furnished the Commission's legal team or the Commission with a statement beforehand
Correct.
to enable the Commission to know what he was going to say and then to make a decision as to what should be done and to have copies sent or notices sent to certain persons that he might have intended to mention. That is the first point. The second point, I think, would be that generally speaking, it would be reasonable to expect that where information that might assist the Commission is readily available, that it be looked at so that it's taken into account before a witness's statement is finalized or before a witness gives evidence. Of course, it depends what the information is, and one has got to bear in mind that a witness doesn't, the information that the witness has doesn't have to be 100% correct.
Correct.
You know, but it would be important to see that where there was awareness that certain information could be checked with relative ease, that could be checked first. Of course, then there is the point which I made earlier on, that different persons, different people adopt different attitudes or approaches to different issues. A few weeks ago, Ms. Jiba's counsel came here when Mr. Nxasana was going to give evidence, and I had argument, and as a result of the argument and my response to it, certain arrangements were made, and Mr. Nxasana was able to continue with his evidence without dealing with certain aspects of it. And he subsequently came back, I think last week or the week before, and was able to continue with his evidence with no objection at all from Ms. Jiba, and without, as I understand the position, even an application from Ms. Jiba for leave to cross-examine him.
Correct.
So the objection had fallen away. Mr. Nxasana is still going, hasn't finished, he will still come back and finish his evidence. So as I say, one keeps on trying to strike a balance. One doesn't want a situation where just because somebody objects to something, then everything stops. But at the same time, one doesn't want a situation where people believe that even if you object, you'll just be dismissed because the Commission wants to continue. One tries to strike a balance, and one of the factors, as I mentioned earlier on, is to say, okay, if we allow the opportunity to have the investigators or the legal team of the Commission interview Mr. X, and he tenders certain information and his bank accounts, and he's prepared to answer whatever questions he may be asked. That's what Mr. Helens said, if I recall correctly. If that process has been done, we might still come back and be able to say, no, that's fine. Let Mr. Dukwana mention what he believes the initials represent. And it may be that at that stage they might say, look, we have been had and we will still get a chance to challenge that's fine. So one tries to strike a balance. Of course, different people will strike a balance in different places.
Correct, Chair.
Yes. So that's the at least one of the distinguishing factors relating to the former president is that we didn't have his statement. It all
Chair.
came as a surprise.
Yes, Chair.
Yeah.
Chair, I see that the Mr. X
Council.
council.
Other than Mr. Helens.
Other than he's present,
Yeah.
certainly they were listening to the news, and that is why they deemed it fit to do a U-turn. But Chair, Mr. Dukwana tells us that Mr. X actually, in a newspaper edition last year, he actually disputed that he is indeed Mr. X. So he says in any case, even if Mr. X is referred to as Mr. X, the context is still out there in the public domain. But as proposed earlier, Chairperson, is now that Mr. Helens is here, perhaps that extended lunch should be proposed, and then we favor Mr. Helens and his and the team of Mr. X with.
But
what
I'm
has
not
been-
sure what prejudice Mr. Dukwana will suffer if we go along with my inclination. Because it's a question of, if he doesn't mention today, he might still be able to mention at a later stage what he believes those initials represent.
But Chairperson, it will
Yeah.
be prudent that the legal team of Mr. X is present, so that in the event they wish to challenge his evidence, they do so, because the issue of reputation, we are told from Mr. Helens that it's at issue here.
Yes, but they have no problem. They are happy with my inclination. Mr. Mokoena accepts that inclination. And as I understand the position, you are not totally against it,
Certainly.
but you have certain concerns.
Certainly, Chair.
Yes, so, but I see that I think your instructing attorney seems to want to say something. I've got to bring this to a close.
Can I please take instructions?
Take instructions, but I want to bring it to a close, yeah.
Instructions.
Chair, I understand that the client is amenable to the inclination, and we must proceed as.
As previously indicated.
Thank you, Chair.
Okay, no, that's fine. I take it that Mr. Helens doesn't have to say anything in the light of that.
Mr. Chair, if
Yes.
you grant Mr. Helens a time, we'll leave here at 6 o'clock. I think he goes with the inclination, Mr. Chair. I'm sure of that.
I think, Mr. Helens, you don't have really to say anything because,
I missed some of it, Chair, but if it is as it was when I left,
Yes.
when you adjourned, then I have
Yes.
nothing to say.
Yes, no.
As shortly as possible.
it is as it was when we adjourned. Okay, all right. Thank you to everybody. Okay, Mr. Mokoena, should we get
Mr. Chair, may the witness be sworn in?
Yeah, okay.
Please state your full names for the record.
Mxolisi Dukwana.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
I'm sorry, I don't know if, it
Yes.
looks like it's working
was
now.
far.
Okay, I think you must give that answer, that last answer again.
Yes.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Mr. Dukwana, we
And
have,
just before Mr. Mkwena, Mr. Dukwana, thank you very much for coming back to continue to give evidence in the commission.
My pleasure, sir.
Thank you. And Mr. Mkwena, you will obviously be alive to the relevant parts of his evidence, and you will.
I've put red stickers where I'm not supposed to go, Chair.
Okay,
Yes.
all right.
Mr. Dukwana, we have placed the file before you, and if you open that file, you'll see that it's being subdivided into 6 folders. Do you have that file?
Yes, I do.
Yeah. And if you go through, there is an index in front of it, which will assist you to navigate, through the file. However, for the purpose of your testimony today, we will be going to folder number 6. And if I may request you to turn to page 1 of that document. Could you please identify the document for us?
The what?
Could you please identify what is that document that you see on page 1? The pages are numbered.
Evidence of Mxolisi Dukwana.
Yes, no, but I think you're looking at the cover page, 10 again. Yes, that's the document. What is that document?
It's I, the undersigned Mxolisi Dukwana.
It's the statement.
It's a statement.
Now let's go to page 34 of that document. And could you please identify the signature appearing there?
It is mine.
And do you confirm that this statement is in a form of an affidavit?
I do.
Yes. And do you confirm the contents of that statement to be true and correct?
I do.
Yes. Now, in your preparation also, you were presented with an affidavit that was deposed to by Mr. Iqbal Sharma. Am I correct?
Yes, sir.
And then if you may turn, please, to folder number 5. Would that be the statement of Mr. Iqbal Sharma, which you had the opportunity to peruse?
Yes, it is.
Yes. Now, let's go back then to your statement. We'll in due course come to that statement of Mr. Sharma. If I may refer you to page 3.
I'm sorry, Mr. Mkwena, I think is there something you should tell me about pagination here? Normally, with these bundles, the pagination is from beginning to end, but I see that this may be different.
It is different, Chair, because the documents that you're having, which are at the beginning of the file, have
Yes.
already been, admitted as evidence
Yes.
on particular set of numbers.
Yes.
So we do not want to disturb that pagination that exists from his initial evidence.
Yes.
That is why we kept it there the way as it is. But if you go to Exhibit 5, we then created it as a separate bundle altogether, which is on folder number 6.
Oh, that's what I want to understand.
Yes, folder number
So-
6, Chair, yes.
So from folder number 6, it's a different
It's a
pagination.
different pagination, it goes with
but
its own pagination.
It holds good for the balance of
Definitely,
the
Chair.
pages.
Yes,
So before folder 6, it's one pagination.
definitely, Chair.
And after folder 6, it's a different pagination.
Different pagination, Chair.
But it's complete. It's from beginning to
To the
end
end,
in
Chair.
that section.
Yes.
Okay.
As we have also alluded to in our opening address,
Yeah.
when we're introducing the documents, Chair.
Okay.
Now, Mr. Dukwana, I was just about to refer you to page 3 of your statement. Would I be correct that, from that page and onwards, you are then reacting to the averments and statements which are contained in the affidavit of Mr. Iqbal Sharma?
It is true, sir.
Yes. Now, in paragraph 6 of that statement, you give a background, and in paragraph 7, you state to the chair as follows: Sharma's statement was not intended to be an application to cross-examine me, but an attempt to respond to the allegation I made relating to him. Notwithstanding the status of Sharma's statement at the commission, I am advised that I need to deal with the relevant matters canvassed in his statement. Further, in Sharma's annexures, there are documents that I purportedly signed, and I will demonstrate that the signature appended in those annexures have been forged. And that's what you're conveying to the chair, am I correct? As a means of a background.
It is correct, Chair.
Yes. Now, may you proceed in your own words and start dealing with Sharma's affidavit from your own reaction with reference to paragraph 8.
I'm sorry, Mr. Mkwena. We are at 1 o'clock, but I was thinking maybe we could go up to 1:15 and then take an adjournment. But we could adjourn and start and come back at 2. If we adjourn at 1:15, we'd come back at 2:15.
Chair, Mr. Zitini is very hungry. He indicates to me, he says now.
Yes?
He says adjourn now, Mr. Chair. So I am normally a creature of instructions,
Yeah.
Chair, but we may adjourn now and come back at 2.
Maybe we should adjourn and so that he can start properly after lunch. Okay, let's do that. We tried to start earlier. It wasn't possible. Okay, we'll adjourn and then we'll resume at 2 o'clock. We adjourn.
All right.
I was so used to our client's name not being used, I didn't recognize his name.